Hi, everyone. Welcome to the webinar today. My name is Alexandra Alvarado. I'm the Director of Marketing and Education here at the American Apartment Owners Association. We are so thrilled that so many of you have signed up for this webinar. I think it's an interesting topic we haven't quite covered before, and one that is certainly going to make a difference if you do ever plan to do a 1031 exchange and you hold property in a trust or LLC, and I know many of you do. What are some of those considerations you should be looking at? So with us today, we have Richard Gann, who is the managing partner at 1031 Capital Solutions, one of our fan favorite speakers. So glad to have you with us, Rick, today. You always bring an interesting take and update on investing and 1031 exchanges. And this is just going to be, I think, a really interesting one that you haven't quite covered before, just so that Rick is actually a licensed real estate broker. He's also JD. He's an attorney, general securities principal, also specializing in 1031 exchange solutions. And many of you I know have read his book, How to Retire from Being a Landlord. If you haven't read his book, we did give you the question option when you registered. So if you said yes to that, you will be getting a copy of his book, and he can mail it to you if you like a hard copy. I know I like reading a printed, good old fashioned hard copy book. So he'll be sending that to you for free if you did select yes. And so make sure that you respond back when he offers you the book with your mailing address. And also, really, I think before transitioning to financial services, Rick practiced real estate taxation and estate planning. So he has a lot of different areas of expertise that I think really is beneficial for you all. So please take advantage of this time to ask him your questions. We are going to go probably about 45-ish minutes, and then we'll have time for questions afterward. And so please put your questions in the question box, not the chat. The question box is the best place because we can keep track of which questions have been answered. And then also, as usual, we are recording this webinar. So please tomorrow look out in your email for the PowerPoint slides and the recording. So if you do miss anything, you have to leave early, we will be sending that to you tomorrow automatically. So no worries there. Rick, thank you so much for joining us again. It's always a pleasure having you speak for our group.
Thank you, Alexandra. I really appreciate that. That was a kind introduction. And Alexandra used the word interesting, which is generous. Hopefully, my goal is to at least keep you awake if possible. But it's pretty rare that anything that we're talking about is terribly interesting. But I will say that in the past, we've had sort of very focused topics. This is a little bit more of a basket of topics that are loosely related, but the common theme is, what are some of the issues that have come up in our experience at 1031 Capital Solutions for folks who have entities that own their real estate, meaning trusts, partnership LLCs, etc. And what are some of the key issues and pitfalls that the folks should be aware of who have some kind of entity that owns their rental properties, and how that may or may not impact both their decision making and their any procedures with regard to exchanging that property down the road. So that is the general topic, and I hope I can share something with you either that confirms what you were already knew or adds something to your knowledge base. And as Alexander mentioned, please feel free to input questions in the Q&A function, and we will do our best, Alexandra and I, to get your questions towards the end. And I always make the promise, and have, to my knowledge, always done a good job of following up to the extent that we don't get a question answered during this session. I always endeavor on a one-off basis via email to get your questions answered. Alexandra provides those to me after the Zoom meeting. And so one way or the other, I want to make sure that we get your questions answered. Now, before we go any further, I am required to tell you that this presentation is not a solicitation. Real estate and real estate securities may not be suitable for all investors. The risks of investing in real estate programs are no less than the risks of direct real estate ownership. Investing in securitized real estate programs typically involves higher fees than traditional investing, and although the name of our company is 1031 Capital Solutions, we cannot give tax or legal advice. A little bit about us, and for those of you who have been on our webinars, you are probably familiar with us by now. Maybe I even have some of my clients on the call. But my office, most of the year, is in Lake Oswego, Oregon. I'm actually in Palm Springs right now. My partner, Jason McMurtry, is in San Diego County. We also have satellite offices in San Francisco and Seattle, as well as team members who work remotely from Denver and Orange County and elsewhere. I'm an attorney by trade, and Jason has an MBA, and we've both been working in this industry together since 1998. I strongly encourage everyone to visit our website, 1031capitalsolutions.com, where we have copious articles, blogs, videos, and ever-growing educational content. In a nutshell, we are a financial services firm that exists for the purpose of helping individual property owners retire from being landlords. And on that note, in May of 2020, we published a book on this very topic, which is available in both print and electronic formats on Amazon. However, as Alexandra mentioned, if you go either order via this Zoom call or go on our website, you can easily find a link where you can order a free hard copy of the book delivered right to your door. I also prefer to read on paper rather than on a computer or tablet. I spend enough time staring at a computer monitor throughout my day. The last thing I want to do is spend my personal time looking at the screen. And so I encourage you to buy the hard copy book. Okay, like I said, we will get Q&A answered. So as we go along here, note your questions and then submit them at the end. And with that, I will just quickly review with you the topics. We're going to do a very brief overview of 1031 exchange rules. Most of you, I'm sure, are familiar with, but it's always good to review. Then we're going to talk a little bit about trusts, and then partnerships and LLCs, some issues around limited liability with respect to passive 1031 programs, and also issues regarding entities and accreditation for purposes of investing in private placement securities. Okay, the basics of 1031 exchanges. As I'm sure all of you know by now, the purpose of a 1031 exchange is to be able to sell appreciated real estate and replace that property with other qualified real estate without triggering the recognition of capital gains and therefore capital gains taxes. And this is now a 101-year-old concept. Over a century ago, Congress put in place the ability to sell a business or rental property and replace it with other business or rental property without triggering capital gains taxes. And in order to successfully complete a 1031 exchange, and when I say successfully complete, I mean a 1031 exchange that results in no immediate tax consequences. First of all, you have to establish a qualified intermediary, meaning a special escrow function, often provided by title and escrow companies, banks, or independent qualified intermediary firms, who hold your funds from the sale of your relinquished property through the purchase of your replacement property. Secondly, you have to replace the entire value of your relinquished property, what we also call the down leg property, meaning that you have to replace both the equity and debt. This is an issue that comes up all the time, and no matter how much we jump up and down and try to remind people about this, I can't exaggerate how often people think that they can pay off their loan, only have to reinvest the net proceeds of their sale and complete a 1031 exchange. And that is not the case. The IRS doesn't care that you had a loan on the property that you sold. If you sold that property for $1 million and you had a $500,000 loan, you need to buy $1 million worth of real estate to do a 1031 exchange. And that means you either have to get a new loan to replace the loan you had, or add a $500,000 of cash to your exchange. But either way, you have to buy $1 million worth of real estate in my example. And one of the benefits of the passive replacement programs that we offer, some of you know, is that they come in with built-in financing, so you don't actually have to go get your own loan. But if there's anything that I would ask clients to remember, if they're going to forget everything else, it's that you need to replace the entire value of the property you sold. Now, there are a couple of deadlines in this process. 45 days after you sell your relinquished property, you have to identify the replacement property or properties that you intend to acquire in your exchange. And then you have a total of 180 days from your close date to actually complete the transaction. On that identification, and we call it the ID letter, the identification letter, you can either identify 3 properties, meaning write down 3 different addresses and your best estimate of what the purchase price will be of those 3 properties, or you can rely on what's called the 200% rule, which allows you to identify more than 3 properties on your identification list, provided that the total value of the properties you identified do not exceed 200% of the value of the property you sold. And we rely on the 200% rule routinely because oftentimes the programs that we are offering clients in a 1031 exchange involve portfolios of real estate, and sometimes there are far more than 3 properties. You should also avoid buying replacement property from a related party. This goes back to IRS rules and regulations that seriously frown on related parties being involved in a 1031 exchange. And then lastly, only rental and business property with an intent to hold for an indefinite period qualifies for a 1031 exchange. Only rental and business property with intent to hold for an indefinite period qualifies for a 1031 exchange. And it's this last bullet point that spills over into some of the issues that we will talk about throughout this hour. Okay, those are the basics of a 1031 exchange. Now, let's talk a little bit about trusts and how trusts play into the capital gains tax rules, et cetera. And let's have a quick Trust 101. And most of you probably, if you don't have a living trust, or at least are familiar with a living trust, that the basic elements of a trust is that a trust has a grantor, a trustee, and a beneficiary. The grantor is the person or persons who created the trust and put the assets into the trust. The trustee is the person or persons tasked with being in charge of the assets in the trust. And the beneficiaries of a trust are the people who, as the name suggests, benefit from the assets that are in the trust. Well, when you create a basic, good old-fashioned living trust, you are the grantor, you are the trustee, you are the beneficiary, and because you are all 3 of those people, the IRS essentially disregards a living trust while you're alive. And in fact, a living trust is disregarded for property tax rules, for ownership rules. We essentially, under state and federal laws, really tend to ignore a living trust, even though you created that living trust during your lifetime, because you are all 3, grantor, trustee, and beneficiary. It's all treated as you, which is great because that makes having a living trust while you're alive very simple from a paperwork process. The reason that living trusts are so popular in California in particular, and other states, but I'd say perhaps more people as a percentage have a living trust in California than anywhere else, is because a living trust avoids probate, and probate in California is the most costly and time-consuming of any state in the union, and so people go to great lengths to try to simplify their estate for their children. And by the way, those great lengths don't have to be that great if you know what you're doing. But a living trust by itself, if done correctly, and with the assets properly retitled into the trust, will avoid probate in California, and therefore, the moment that you pass away, having created a living trust, your living trust owns the assets before that moment. The living trust owns the assets after that moment. There's no need for a probate because technically the entity that owned all of your assets, it's not you as a person, it's you via your living trust. And because the purpose of probate is to determine who should own assets when you die, you don't need a probate when you have a living trust because you've already essentially assigned those assets to a trust entity that continues to exist before and after you pass away. And then from an administrative perspective, a living trust can enhance your ability to sort of control the disposition of your assets from the grave by giving you the ability to put far more terms and conditions on how your assets are distributed than you could achieve through a will in probate. So that's your basic living trust. Essentially, the benefits are probate avoidance and greater control of your estate after you're gone. Now, the AB living trust, and I can imagine some of you have, if not most of you, if you're in California, probably have AB provisions in your living trust. And this adds an estate tax benefit by allowing both spouses to apply their lifetime estate tax exemption toward their children. And what I mean by that is each one of us, under IRS rules that Congress modifies on a fairly regular basis, we are all allowed as U.S. citizens to pass on a certain amount of money to our heirs when we pass away without being subject to estate tax. And so we call that the lifetime estate tax exemption as a general term. And some of you may remember when I started in this business years ago, the lifetime estate tax exemption was $600,000, meaning that if you had more than $600,000 or a married couple had more than $1.2 million, everything above that was going to be taxed at 50%, and it was an incredibly punitive and egregious tax. It still is, but to the extent that it was affecting essentially middle-class people, this created a cottage industry of estate planning along with tax-free insurance strategies designed to try to mitigate, if not offset, the effects of the estate tax. Well, thankfully, over the years, starting in the 90s and then forward, we saw this gradual increase of the estate tax exemption that is now millions of dollars. And as a result, the number of families in the United States that are subject to the estate tax realistically is much smaller than it was when I started this industry, where anyone that owned a home in California was going to be subject to estate tax. And so the purpose of the AB trust was to allow the surviving spouse to pass on the entire estate to the kids by adding together the exemption of the first spouse to die. Meaning that if you didn't have an AB trust, then the the first spouse who passed away would essentially use his or her entire exemption on his or her spouse. That exemption would be lost, and now the surviving spouse would now only have his or her lifetime exemption, and so the AB trust allows the first spouse to die to apply his or her exemption towards the kids rather than expending it on unnecessarily on the surviving spouse. And when you have an AB trust, half of that AB trust, usually known as the bypass trust, becomes irrevocable, meaning that the surviving spouse cannot change the beneficiaries. However, the surviving spouse still receives the benefit of the assets of everything in that trust. And that's a critical distinction, because what you really end up with at the death of the first spouse is a trust that is half irrevocable and half revocable. Okay, then we have the third category, which is a truly irrevocable trust. And an irrevocable trust could be a trust that started as a revocable trust and became irrevocable when all of the grantors died, which happens on every living trust eventually, or the grantors intentionally made the trust irrevocable at the outset for purposes of moving one or more assets out of their estate, either for tax reasons or liability protection or both. But either way, there are trusts that, for one of those reasons, today is irrevocable. And when a trust is irrevocable, it means nobody can now change the terms of the trust. And an irrevocable trust is treated as a separate legal entity, just like any other legal entity, with its own taxpayer ID. It files its own taxes every year, and it is completely different than the way we treat a living trust during the lives of the grantors. And at the risk of oversimplifying, these really are today, every trust is, in terms of the types of trust that you and I would have, every trust fits into one of these categories. So how do the different types of trusts affect the capital gains tax rule? Let's bring this back to sort of what is relevant to real estate ownership and capital gains tax. Well, in the case of the AB trust, and again, this depends on what state you're in. If you are in a community property state, which includes Arizona, California, Idaho, Louisiana, Nevada, New Mexico, Texas, Washington, and then for whatever reason, Wisconsin. And I say why Wisconsin, because this is a holdover from states that were part of Mexico, and somehow Wisconsin is also a community property state. But if you are in a community property state, and I know most of the people on this call are in California, then under a quirk of IRS interpretation of community property state law, when the first spouse passes away with community property, there is a full step up in basis on that property. In all other states, there is a partial step up in basis, and we could go down a rabbit hole in terms of how assets are titled and how that affects step up and et cetera. But the most important distinction for purposes of today is to recognize what is going to happen with the step up in basis at the death of a first spouse, particularly with real estate. And again, it depends on whether you're in a community property state or not. And oftentimes when we're doing planning and we're talking about the 1031 swap till you drop strategy, which I know is crude, but this idea that you can keep a 1031 exchanging up until the point where you pass away. Well, in California, that doesn't have to translate into a strategy that requires a step up in basis at the death of both spouses. That capital gains tax deferral can be wiped away at the death of the first spouse under the community property rules, which can help affect your decision-making process in terms of the importance of doing an exchange today and recognizing that you may be able to access that property and liquidate that property during the life of the surviving spouse in a way that you might not be able to do otherwise, because of the fact that under community property law, that capital gains tax has been wiped away as a result of the step up in basis at the death of the first spouse. That's a critical thing to be aware of when you are considering a long-term consecutive 1031 exchange swap strategy. Now, at the death of a surviving spouse and you've got an irrevocable trust, heirs may receive another full step up in basis or a partial step up in basis, depending on what occurred at the death of the first spouse and the type of trust and location of the estate. And again, I am bringing this up to trigger awareness. We don't have enough time to go into all the different permutations of how a combination of state location and trust type could affect the step up in basis for heirs. It also may depend on how much time has passed between the death of the first spouse and the second spouse. But again, it's important to be aware of how, especially with a married couple, how the death of the first and then the surviving spouse are going to affect the step up in basis on a property, and then how all that is going to tie into your long-term strategy with your 1031 exchange plans, and also with respect to your estate plan. And if you have a scenario that you want to run past us, again, understanding that we do not give direct tax or legal advice, but we can certainly talk you through your situation. I encourage you to go on our website, schedule a call with us, and I'd be happy to talk to you about your particular situation. If you have questions about how your current estate plan could affect the capital gains consequences of you or your spouse dying down the road. Okay, as we heard earlier, a fundamental rule of 1031 exchanges is that they are only available for properties that you intend to hold for business or investment purposes for an indefinite period. And frankly, for most exchanges, this is not a requirement you need to worry about. The vast majority of our clients, and I'm sure people on this call, bought a rental property with the intent to hold it indefinitely, didn't know when they were going to sell it in the future. There's no question about the fact that it qualifies as a rental property or perhaps as a property for your business or both. But this rule can wreak havoc when investors change the ownership entity to which the intent is attributed. And this is where the quirk of this rule can be very counterintuitive, because you may not really think of the entity as anything more than some piece of paper that's sitting in a drawer. But from the IRS's perspective, you and your LLC, or you and your irrevocable trust, or you and your partnership are different entities when it comes to intent. So again, a 1031 exchange requires intent to hold both the relinquished property you sold, and the replacement property for business or investment purposes for an indefinite period. And changing ownership, it just inherently disrupts this intent, because you can't apply that intent to the exchange anymore, because you've changed who the owner is. And so as a result, now you have to look at what was the intent of this entity that now owns this property going into or coming out of an exchange. Some of the entities that may be involved in exchange could be disregarded, while others create these issues. So under the category of likely disregarded would be to the extent that you're doing a 1031 exchange and you realize, which happens, oh, we never put that rental property in our living trust, or we thought that the attorney did and we didn't, or whatever. Or maybe you just, for whatever reason, you're taking advantage of the fact that you've sold the property and buying a new property to ensure that the replacement property is in your living trust. That's great, and the vast majority of accountants and qualified intermediaries will tell you that that's not a problem. Although it could, in an audit, you could raise a red flag or pique the interest of an auditor when they see a property being sold in your name and purchased in a trust. But under the rules, because your living trust is disregarded, that would not violate this requirement of this sort of continuity of intent to invest. The same applies to a single member LLC. And in both of these cases, it really comes down to, is the entity that owned the property before and after the change, does it have the same taxpayer ID? And in both cases, your living trust or a single member LLC, you tend to not have a separate taxpayer ID. And so from an IRS perspective, it's essentially the same person. And so we don't get into this thorny issue of intent. But the red flag will come up when a partnership entity, for example, is dissolved leading into a 1031 exchange, or a multi-member corporation is created going into an exchange. Anything where an entity has been dissolved or is being created that has a separate tax ID number that is treated by the IRS as a true legal entity, that's where you're likely to get into some issues. So it's perfectly fine and legal to form, change, or dissolve entities that own 1031 exchange property. The key issue is when those changes are being made relative to the timing of the exchange. And what I've attempted to do in my limited graphic design skills on this slide is basically, with the 1031 exchange happening there in the middle, is to demonstrate kind of a green safe zone and then a red danger zone with respect to activity around an LLC. You see the word partnership, that could mean a company, an LLC, a partnership. And so if you are far enough in advance, and I'll use an extreme example, you're 3 years away from doing an exchange, then no problem. You could dissolve a partnership that owns a property, and you could have 3 people that were in an LLC together and dissolve that and convert everyone to 1/3 tenant common owners. And if you did that 3 years ahead of a 1031 exchange, no one is going to care about that. That's not a gray area. That's not a red flag. That's not a problem. As you get closer and closer to selling that property or buying the replacement property, that's when you get into the red zone. And the same logic applies immediately after the exchange. So it's like I said, it's a matter of time. And the worst example would be someone who's literally, they've sold it, they're under contract. The rental property is sold, there's an LLC, and the partners have decided that they're going to dissolve the LLC while that property is in escrow to be acquired, and then they hope to, on the other side of the 1031 exchange, these 3 partners are each going to go buy 3 properties and go their separate ways in an exchange. And unfortunately, you cannot do that. That is the absolute example of what you cannot do. And so where you get 10 answers from 10 different CPAs or tax attorneys is how far in advance of that exchange, or how far after the exchange do you need to wait to effectuate these different changes? And again, as you can see in bold red letters, we don't give tax or legal advice, but there is guidance in some case law on this. But there's also a lot of scenarios that the IRS has never spoken to, and those are the situations where tax attorneys and CPAs are trying to glean from cases what the IRS may or may not do in any given situation. And the safest answer is always just, if you want to dissolve your entity, go ahead, but then you're going to have to wait a while to do your exchange. And I don't have an answer for you on this call, because there is no magic answer as to how long you need to wait after you dissolve an entity to do an exchange. But it's definitely measured in months. So let's talk about 3 possible scenarios for satisfying a partner who wants out of the group after the LLC conducts a 1031 exchange. And the reason I use this example is because I want to take the safe route in terms of, let's just assume that the decision has been made amongst these partners to do the exchange after it was too late, meaning that they can't go back in time and dissolve the LLC and then wait a couple years and then do a 1031 exchange. So they've agreed, under advice from their tax professional, to go ahead and do the 1031 exchange as an LLC or as a partnership, and then figure out how they want to break up from each other after the exchange. And so I put together 3 scenarios that we've seen where this can be accomplished, and whether this appeals to the group really just depends on the circumstances. But in scenario 1, the partnership buys the 1031 replacement property. So they sold a property and they bought a property. And then partners A and B decide to buy out partner C. And this is actually the cleanest way for A and B. This is the cleanest way to solve this problem, because this all assumes, by the way, that in each of these scenarios, partner C just wants out for whatever reason of the partnership, and A and B are cool with sticking together. And so partner C wants out, and so partners A and B, after the exchange, they say, hey, no problem, C, we'll just buy you out. Now, of course, this has one major caveat, which is A and B have to have enough money between each other to contribute into the partnership to buy out partner C. But if the partners have the cash to do that, great. They can write a check to partner C in exchange for his 1/3 interest in the partnership, and he's out. But of course, C is going to pay tax on his buyout, because he converted his 1/3 partnership interest to dollars, and that's a taxable event. Now, if C is so motivated to leave that that's what he wants to do, then fine. But C may not want to pay tax to get out, and so scenario 1 may not be practical from C's perspective. So the next scenario is, again, the partnership as a group does a 1031 exchange. This time, they invest in a passive real estate program, like the type that we offer, which is investing in one or more DSTs or other private placement programs, where you essentially have a fractional interest in an institutional portfolio of real estate. And so you invest in a passive real estate program, and then later dissolve the partnership. At that point, each partner now has a separate interest in the passive replacement program, say a DST, and now each of the partners owns their respective 1/3 interest in the DST interest that the partnership bought originally. And then when that DST property liquidates, they can now go their separate ways, and they can each either pay the taxes when that property sells, or they can do another 1031 exchange and go do whatever they want. But they're no longer tied to each other in terms of the future 1031 exchange strategy. And we have done that, and that works great, provided that everybody is comfortable with remaining in the passive replacement program for 5, 6, 7, 8 years until the property sells. Then scenario 3 is the partnership buys 2 replacement properties, and one property is 2/3 of the funds are put into, again, I'm going to say a DST, a passive replacement program, and then 1/3 is put into a small rental property. So suppose there was $1 million, and partner C really wants to be able to get out and be on his own as quickly as possible. So you put 2/3 of $1 million into a DST, and you put 1/3 into some rental property, with the understanding that that property in the relatively near future is going to be liquidated, because you can quickly turn around and sell a small rental property in a way that you can't do with a passive replacement program. And so again, you dissolve the partnership. A and B are now individuals that are no longer in the partnership, but they are co-owners, so to speak, of whatever DST or passive replacement properties that they bought. And C now has a small rental property. And then after some amount of time, let's say after one cycle of doing tax returns, maybe it's 2 cycles of doing tax returns, now partner C can sell that property, go do another exchange, and he can liquidate even faster than A and B, who are waiting for the DST property to sell. So we've seen all 3 of these scenarios. We've participated in all of these 3 scenarios. And I thought it was important to share this with you, so that if you are in a partnership or LLC, and maybe you are partner C who wants out, or maybe you are more like A or B and you've got someone else in your group who's itching to get out, there are strategies to, and sometimes it requires a little compromise, but there are strategies so that everybody can get what they want and get the tax consequences they want, without trying to roll the dice and do things during a 1031 exchange that are going to disallow the exchange if you get audited. Okay, a couple more points here. With regard to limited liability, and since I mentioned passive 1031 real estate programs, there's an array of different types of passive structured programs, institutional real estate programs that qualify for a 1031 exchange that you can invest in. And many of our clients, when they invest in, say, a DST, for example, and they had an LLC for their rental property, which, by the way, very necessary, especially in California. I highly recommend that if people own rental property with an LLC or other entity, to give them legal liability protection. So that's important. But if the only thing in your LLC is your rental property, and you sold that rental property in a 1031 exchange, and you invested in an institutional passive replacement program, it is no longer necessary to maintain your LLC beyond what's necessary to satisfy the 1031 exchange rules. So maybe a year and a half or 2.5 years later, some period of time after you've done 1 or 2 tax cycles with your LLC paying the taxes on your new property after the 1031 exchange, we will routinely help our clients dissolve that entity, because as most of you know, you're paying $800 a year just to have the LLC, and then on top of that, the additional accounting costs of having to do a return for the LLC, and you no longer need the legal liability protection of an LLC when you invest in a Delaware statutory trust, because that legal liability protection is inherent, is already built into the structure, and you're essentially paying for legal liability protection that you don't need, and that's a waste of money. And so, this is a benefit of these types of programs, is it allows you to finally dissolve this LLC that you never really wanted to have in the first place, but you had to protect yourself. You can do a 1031 exchange into a passive replacement program and get rid of that LLC after all. And if you're interested in a 1031 qualified property that is offered as a private replacement under U.S. securities rules, the person or entity that owns the property must be what's called accredited. You must be an accredited investor. And whether a person or entity is accredited under federal law, unfortunately, depends on the ownership structure. And some of this can get a little silly because the distinction between some of these entities, for a lot of people, including me, seems meaningless, and yet can have a big difference in whether you're considered accredited for purposes of being able to invest in a private placement. So let's start with the easiest, which is just a person or a married couple as individuals looking to invest in a private placement. And an accredited individual is someone who has $1 million of net worth, excluding your home. That's important. So you don't get to count your house, but otherwise, if you have $1 million of net worth, meaning assets minus liabilities, then you are an accredited investor. There are some people who don't have $1 million of net worth, but they qualify as an accredited investor because they have a high income. So if you are single and you earn $200,000 a year, or you're married and together you earn $300,000 a year and you expect to continue that level of income, then you can qualify as an accredited investor, even if you don't quite yet have the $1 million of assets. Most of our clients are accredited under the asset test because they own rental property, and that's why we're working with them in the first place. Now, if the entity that owns the rental property in the 1031 exchange is an LLC, for example, and the LLC is now the entity that's going to buy a private placement to replace the rental property that was just sold in the 1031 exchange, there's a different set of rules. And if that LLC has a total of $5 million of assets, not net worth, $5 million of assets, then the LLC qualifies as an accredited investor. If the LLC does not have $5 million of assets, but each of the individual members of the LLC are accredited investors under the test I just mentioned, then the LLC will qualify by virtue of all of its members qualifying as accredited investors. So there's two ways for an LLC or limited partnership or corporation to qualify as an accredited investor. Where we can run into trouble sometimes is when someone has inherited a small fraction of a family LLC, and that young person doesn't qualify by either from their net worth or their income, and that can disallow the entire transaction because somebody in the group is not an accredited investor. And I can't tell you how frustrating that is for the client and for us when we've moved along in the process and then find out that somebody is essentially disqualifying the whole thing because they're not accredited. So it's something to keep in mind for those of you that have these, especially these complex family entities, family partnerships, etc. And then lastly, going back to our original topic on living trusts, AB trusts, and irrevocable trusts, we do have on a regular basis clients where an irrevocable trust is doing a 1031 exchange. And in this case, the $5 million asset rule is the only rule available to an irrevocable trust. In other words, if everyone who's involved in the trust is an accredited investor, but the irrevocable trust itself doesn't have $5 million of assets, we cannot move forward with that transaction. And that is, nothing is more frustrating than that. And so we've become very sensitive to this, and we do our very best to get these issues out of the way early on so we're not wasting anyone's time. But keep in mind, if you are a beneficiary or a trustee of an irrevocable trust and you're intending to do a 1031 exchange into a private placement program, you need to have $5 million of assets in the irrevocable trust to acquire private placements under U.S. securities rules. And then lastly, because of everything we've talked about, it's important to establish an early relationship with a 1031 investment advisor. And some of the benefits of doing that, whether you're working with us, which I of course hope you would, or at least someone who does what we do, is first of all, we will help you do a cash flow analysis on your rental property, and somewhere along the way, Alexandra, if she hasn't already, will provide information so that if you want to have us do a cash flow analysis on your rental property to help you decide whether to keep, sell, or exchange that property, we can do that for you. We can also provide a tax illustration to determine if a 1031 exchange is warranted based on the tax consequences. It's pretty rare that we would advise someone to go ahead and pay the taxes and not do a 1031 exchange, only because the combined state and federal tax consequences of not doing an exchange are so punitive, but it happens. And we do what I think is an amazing job of educating our prospective clients on the various options for investing in passive 1031 investments. And again, we can ensure that the full range of private placements are available to you when you need them, because in addition to this accreditation rule, you cannot invest in a private placement, whether it's a 1031 exchange or any kind of private placement, with an advisor that you don't already have a pre-existing relationship with. And so sometimes people have an investment that they want to invest in. They're willing to give their money right now to invest in a particular program, and yet they are prevented from doing so by these rules, because the rules that are supposed to protect the investor in the first place are essentially preventing the transaction, because we cannot solicit, the industry cannot solicit non-clients. And there's people with whom we do not have a pre-existing relationship. We cannot solicit, with rare exceptions, private placement securities to people that we don't already know and aren't already talking to. And we get most of our business from referrals, or by talking with people far enough in advance so that by the time we're ready to invest, they are bona fide clients and not strangers coming off the internet. But if you're the kind of person who likes to sort of quietly sit to the side, do a lot of research on the internet, and then boom, pull the trigger on an investment with somebody you don't know, you could find yourself unable to take advantage of that opportunity because you haven't established a pre-existing client relationship with the advisor offering that particular program. And here we see a poll that has popped up, offering the opportunity for you to have a complimentary consultation in advance of doing a 1031 exchange. And of course, we would love to schedule a time to talk with you about planning for a future exchange. Or maybe you have an exchange pending and you need some help. And with that, Alexandra, I've come to the end of my formal comments, and we've got a few minutes left, and I'm happy to go over the hour if people want to stick on. And it looks like we've got a handful.
Many questions have come in already. I'm going to leave that poll question up just a little longer for you all to get a chance to respond to that. Hope you take advantage of Rick's advice and his consultation that I think is just so helpful. Claudia asking, the new property needs to be on the same name as the original, right? What happens if one of the owners have passed and the property has a mortgage?
So this is a common scenario. And so it does happen that, especially between married couples, understandably, somewhere along the way, nobody bothered isn't the right word. They just didn't, they weren't thinking because a husband or wife passed away, and title wasn't re-recorded to reflect the passing of the first spouse. The IRS is not going to trip you up because the title on the property at the time of sale didn't reflect the fact that one of the previous owners had died, because the surviving spouse in a property that was held as joint tenants with right of survivorship automatically became the legal owner of that property, even if the deed wasn't re-recorded. So the short answer is that is not something you have to worry about. That is not a red flag in a 1031 exchange. And in that scenario where you had a rental property, you're now selling the rental property, and the deed had includes the name of somebody who passed away. If the bank didn't catch that earlier, now the bank's going to receive the the proceeds to pay off the loan. So you've got the loan being paid off and the property being sold, and that entire exchange is attributed to the surviving spouse. So when you go to replace that property in a 1031 exchange, the IRS, for 1031 purposes, is going to treat you as the owner of the entire property, and that includes the loan that's attributed to you. And so you will need to do a 1031 exchange to replace that property. However, because of the fact that the first spouse has passed away, you need to take a look at whether or not you need to do a 1031 exchange in the first place, because if it's been recent and there's been a step up in basis as a result of the first spouse passing away, there may not have been enough capital gain in between the time that your spouse passed away and you're selling the property to justify doing an exchange. So that goes back to this issue of understanding, the step up in basis and how that plays into your decision making on an exchange. If it's been 10 years since the first spouse passed away in this example, then you're probably still going to need to do a 1031 exchange, but you ignore the fact that the deceased spouse is still on title and move forward as though you own the property and it's your property, your loan, and then you follow all the same 1031 exchange rules that we talked about, and you would need to go buy a replacement property of at least the same value as the sale price.
That makes so much sense. And I think that's why it's so important to have a consult with someone like you so you can know, right, if it makes sense for you to even do the 1031 exchange. We were just talking about this before the webinar that, a lot of times when you talk to some of your clients, they might decide, I'm just going to keep the property. I don't need to do the 1031. And that's very valuable too, to know that you are in a good position if that's the case. So Therese asking a different question. I am gifting my son a rental property from my trust to his LLC. What value should I put on the house as a gift?
Boy, I would love to talk to you about this, and because I could spend an hour talking about this gifting situation that we don't have, and so I'll tell you what. Please note the information here. My email address is rick@1031capitalsolutions.com. Send me your contact information. I'd love to talk to you, because there are so many pitfalls with gifting, and so I don't want to tell you not to do a gift, but I'd love to talk to you about what may be a handful of issues that may not be considered, because I think a lot of times what people are trying to achieve with a gift can be achieved other ways that are more beneficial from a tax perspective. But the one thing I will leave you with is the understanding that when you gift a property to a child, your child now takes the cost basis in that transaction, and they lose your opportunity to get a step up in basis as a result of passing away. And so when your child sells that property down the road, they're going to have to pay capital gains tax on going all the way back to when you bought that property. So gifting, when it comes to highly appreciated property in this situation, may not always be the best approach. But feel free to contact me, and I'd be happy to talk to you about it.
Adriana asking here, a little complex of a question. I have a rental property that is in an irrevocable trust and has three trustees who will inherit the property. However, the landlord is still alive. One of the trustees lives in the same state as the property and manages it on behalf of the landlord. Will the Prop 19 affect the taxation of out-of-state landlords? How can the proceeds be distributed?
Yeah, I think that's another one I think I'd love to tackle offline.
Yeah, I think so. That is a tricky question for sure. And I'm sure there are a lot of other questions you might have for Adriana. So, Adriana, Rick will reach out to you offline if you want some more detail on that. Let's see, here's another one from Mitra. Would you expand one parent that has revocable trust on primary resident and rental? I think I don't think I understand this question too much. Mitra, if you could rewrite your question, I think it might have some typos in there. It's a little tough for me to understand there. Um, James saying, I have my resident in a land trust for over 40 years and have other properties in my personal name and was considering putting all of the properties in the land trust, or should I look at different types of trusts?
Well, this has been coming up a lot lately. There are strategies that people employ by putting their properties in trusts that are uh, ostensibly domiciled in other states that have better creditor protections
Mhm.
for the grantors in California, which does offer. And what's tricky about this is that you've got this conflict between different goals, which is on the one hand, you're trying to protect yourself from a liability perspective. And by the way, I'm assuming that's the premise of this.
Yeah.
So if it's not, again, but but uh, when you when you transfer an asset to an entity that is irrevocable uh, for purposes of liability protection, and that may be unquestioned in terms of having done that. But now you've moved that asset out of your estate, so to speak, and so you, you could end up trading one benefit for another, which is okay, you've achieved asset protection, but you've lost as a result of that asset protection, you've lost the opportunity for the step up in basis upon death. I have heard that from asset protection attorneys that there are ways to draft these trusts so that you have what's called an incomplete gift of the asset, and it somehow rides the fence between providing the asset protection you want today, but doesn't treat the property as being outside your state for step up purposes, and that is outside my wheelhouse. And so I'm not an asset protection trust attorney, and so I unfortunately I have to defer to other experts on whether or not the particular type of trust they have has resulted in the asset no longer being in their estate for estate purposes. And so again, you know, you may have accomplished what you want in terms of while you're alive, having limiting your liability and protecting those assets, but you may have done so at the cost of your kids not getting a step up in basis when they inherit that property.
Mm, yeah, that's a really good point. Definitely good to talk to an asset protection attorney about that and see where that line is. Eva asking here, we sold a rental property and escrow closed April 1st, 2024, so 3 days ago. We have the settlement check, but have not deposited. Can it still be considered for a 1031?
I don't have great news for you. The proceeds in a 1031 exchange, the proceeds of the sale have to go directly from escrow to the qualified intermediary in an exchange. And so if you have receipt or constructive receipt of those funds, then technically you've already blown your opportunity for the exchange because you are now in control of that money. And in a 1031 exchange, the procedure is that during escrow, you actually set up an account with a qualified intermediary, which is sort of a specialized escrow function, really. And the instructions to the escrow agent are upon closing, the money is to be wired, and this is all spelled out in the amendments to the escrow instructions, are to be wired from your escrow account to the qualified intermediary. And it sounds like what you've got a situation where that step was missed, and now you've got a check in front of you, and by virtue of holding that check under the strict interpretation of the rules, you likely have now missed your opportunity because you've got the check in your hand. And I don't think there's an exception for giving the check back and having that check routed to a qualified intermediary. But you know who you should talk to is a qualified intermediary about that. And knowing that this is a lot of people are watching this, and this is going to be recorded. I am not going to tell you that there's a loophole you can take advantage of. But talk to a qualified intermediary, describe the situation, and see if it's not too late for you to fix this. I'm not hopeful for you. I'm sorry that happened.
Yeah, it's always good to get started on this early. So let me go to another question here. Wes, I have two investment properties, each with its own LLC. Can I do a 1031 exchange for both properties and roll into one replacement property with a new LLC name?
Well, if each of these LLCs are single member LLCs of which you're the only member and you've been reporting these LLCs under your own social security number, and then your intent is to then on the back end have one property with one new single member LLC, and really these are just sort of they amount to really just disregarded entities in each case. I would think that would be okay. But if these are truly separate entities, and you've been filing separate tax returns, and now you want to consolidate into one, I would think that you'd have to do the exchange on a prorated basis so that the property is acquired by both LLCs as tenants in common to start, and then maybe after a couple tax return filings, then you would basically recapitalize, just convert those LLCs into one LLC, and then so it's a multi-step process. So I think you can do what you're trying to accomplish. Whether or not you can do it all during your exchange, I think really depends on whether or not those were disregarded LLCs in the first place. And if not, yeah, this goes back to what I was saying: is you can't change horses midstream when you've got actual legal entities owning the property.
Wes had another question. Can a replacement property be held for a certain period of time, let's say 2 years, as an investment rental property, and then after that period be used as a vacation home while still maintaining the tax deferral from the 1031?
Yeah, we've talked about this on a prior webinar, and the IRS has what's called a safe harbor rule on this. I talk about this in our book, and so this is a pretty tried and true strategy where the IRS, if you wait that 2 years, then you have a bona fide legitimate rental property for 2 years, and 2 years following an exchange, and then after that convert it to some degree of personal use, whether it becomes a vacation property or your permanent residence. This is okay. This is not a gray area as long as you follow the timelines in the safe harbor. And so 2 years is the rule, and you have to operate that property as a true rental property and go through all the procedures and all of the management, everything you would otherwise do, even though in the back of your mind you intend to maybe use or occupy that property down the road. you need to operate it as a true rental property for those 2 years. And if you do that, then you should be fine.
Okay, good. Nazif, what about if the LLC stays the same members, pre-sale of existing asset, and then acquires a new asset with the same members? That's okay, right?
As long as the entity is, as long as the entity itself is on both sides of the transaction, where the IRS doesn't allow you to do is dissolve. It's what they call drop and swap. You can't in the course of a 1031 exchange dissolve an LLC and have those three partners then buy the replacement property together and do that all at the same time in the middle of an exchange. That goes back to the diagram I was sharing with you earlier. So even if everybody's still involved, it still violates the principles of the exchange, because the entity that had the intent to own the property was dissolved, and so that entity needs to be on both sides of the exchange, and you can't do the dissolution and convert that from an LLC to three human beings owning that property until some time has passed after the exchange. And so I hope that answers your question, but of course, if the LLC itself is doing the exchange, then that's not a gray area at all. LLCs and corporate entities do 1031 exchanges all the time.
Yeah. Yeah. Okay, great. That's good news. Howard asking, what is the IRS audit rate for 1031 exchanges?
I don't know. Honestly, where we hear more audit activity is from the Franchise Tax Board of the state of California. They are far more aggressive on 1031 exchanges than the IRS. Having said that, as everyone here probably is aware, there has been some significant increased funding in recent years for the IRS, and legislation has been passed to beef up the IRS and its auditing capacity. And I would imagine over the next 5 years, the amount of auditing activity that's done on 1031 exchanges will increase compared to the last 5 years. But it's for our clients, I think there's far more risk of getting a call from California Franchise Tax Board than from the IRS on an exchange.
Yeah, it's pretty standard procedure. So, okay, another question here. Bo, can you talk about the original transfer rule to delay real property tax assessment in California? Are you familiar with that?
Yeah, now we're getting into kind of the Prop 19 questions and what's gone on and how things have changed in terms of being able to pass on property to your heirs and maintain your assessed value. And there's a couple of details that in that, but the biggest change from the way things were for 40 years up until a couple of years ago is the fact that, and I'm going to paraphrase, but now instead of just being able to pass on to your heirs any real estate that you own and be able to preserve that assessed value until they sell the property, now the only property that really qualifies, again, we're talking about an inheritance scenario, is a property that your kids are intend to occupy, where it was your home and your kids are going to move into your home. So what used to be a very broad opportunity for kids to inherit property and keep the property tax bill the same, now has been limited to an incredibly tight scenario, which is you inherit a home from mom and dad, and then you move into that house so that you can live in it. That is now the only opportunity to keep mom and dad's property tax assessment. And so I think this is going to really shake up a lot of people's decision making, because we've met clients who aren't selling their property because they believe that they believe that they can hold on to this underperforming rental property, whether it's commercial, industrial, residential, and their kids will benefit from keeping the property tax bill. And by the way, even if that's true, if it's really underperforming, the fact that you get to keep the property tax bill low may not justify holding on to a poorly performing property. But setting that aside, now that's not true anymore. And I think I think a lot of people aren't aware of this. And so if you're holding onto a rental property that you otherwise would have sold because you want your kids to have the opportunity to inherit that property with a lower property tax base, that ship has sailed, and it's time to reconsider selling that property on the merits and not holding on to it for a property tax benefit that no longer applies.
Yeah, that does change things. Diane asking a similar question. I heard that if you go from the trust to the grandchild instead of the living child, that they will get double taxed. Is there a way to bypass the double tax through a 1031 tax exchange?
Well, now we're mixing some apples and oranges here, and then you get into what's called the generation skipping tax, trust, and yeah, this is an hour seminar unto itself. But but the 1031 exchange and the capital gains tax deferral, and then you've got estate taxes. So you're mixing a couple different taxes, here when it comes to generation skipping. And yeah, again, send me an email. I'd be happy to to discuss. Yeah.
Okay.
Again, caveat: no tax or legal advice.
Yes. Peter asking, what about S corps? So any comment there on that? How might that might be different?
Well, with regard to the rules that I was describing in terms of entities and dissolution and 1031 continuity of ownership, excuse me, there is no distinction. There are other tax distinctions in terms of how you are taxed while you own property, and some advantages of different C corp versus S corp. But that's outside the context of really what I was focused on today, which is an entity, excuse me, an entity of any kind that is reorganizing, recapitalizing, dissolving, making significant changes to ownership or just no longer existing in anticipation of an exchange. And an S corp doesn't make any difference in that context.
Okay. How would you 1031 exchange with multiple land trusts?
Yeah, I think that's too open of a question. I'm not even sure.
All right, David. We'll contact you after here. Diane followed up here. So if I understand you correctly, you can sell a rental property and do a 1031 exchange and convert to stock and ? What else besides buying another rental property? Can you do a second? I think she's a little confused there what you can do.
No, so you can only, when we're talking about private placements and investing in institutionally operated real estate, these are the best example of this is a Delaware statutory trust. And in a Delaware statutory trust, you are still investing in real estate from an IRS perspective. The only difference, not the only difference, the biggest difference in terms of title and registration is that in a Delaware statutory trust, it's the only example where you are not on title on the deed recorded at the county recorder's office. Meaning you do a 1031 exchange in any other context, your name is on the property that you bought at the county recorder. The DST is the only example under 1031 rules where 200-300 people can all invest in a Delaware statutory trust. The only recorded entity for that property is the Delaware statutory trust, but it's got 100, 200, 300 beneficial owners recorded on its books, that qualifies as a 1031 exchange under a revenue ruling from 2004. And there are a couple other examples of syndicated 1031 exchange passive replacement programs, syndicated TIC programs, mineral rights programs, but the DST is the most common example. So when I wasn't intending for this to be a DST webinar, but when we talk about, when I say a passive replacement program that is syndicated as a security, we're not talking about stocks, but this is real estate that is real estate for 1031 exchange purposes, but because of the fact that it is syndicated and that you are investing without having any direct control over the property, it also falls under securities laws. And so this is an area where tax law, securities law, and real estate all overlap with these 1031 qualified DST programs. And so if I gave you the impression that there's opportunity to invest in anything other than in real estate in a 1031 exchange, that is not the case at all. You are still at the end of the day investing in real estate. It's just structured in a way that is, quote, passive, because you're a fractional owner of a property that some institution is managing, but it is still real estate.
Good clarification there. Pam asking, can you put half of rental properties sold into a 1031 exchange and a smaller amount into a Delaware statutory trust without being penalized?
That's a great question. And yeah, we have essentially at our firm two scenarios that we deal with every day. One is a client who comes to us and says, I'm selling this rental property, and Rick, I want you to be in charge of replacing the entire value in a portfolio of DST programs. And of course, we love that scenario. But just as often we have a client that is, maybe they're selling a $5 million property and they found an amazing $4.2 million property that they want to replace that property, and they still have $800,000. And what are you going to do with that money? And they don't want to go buy a condo or whatever, and so they need a place to put that. Otherwise, it's going to defeat the whole purpose of doing the exchange, and they're going to pay, $400,000 of taxes. And so we will do a DST, I call a stub amount, where we are filling the gap between the total amount you needed to invest for 1031 exchanges and whatever other property that you acquired. So you can mix and match between traditional directly owned real estate and DST programs, as long as you've acquired the total value that you need to acquire. The IRS doesn't care how you cut that up between properties or the properties in DST.
Yeah, those DSTs can be a real lifesaver there to make that 1031 work. David has an interesting question. What do you know about a 1031 exchange to a temporary property until you find a better opportunity to preserve your 1031? I know a lot of people have this issue because you have to pick the properties very quickly,
Well, this goes back to this whole idea of intent. The intent to hold a property indefinitely. And if I can sear into your mind the requirement, it's intent to hold a property indefinitely. And what you've touched on is the exact reason why developers aren't allowed to do 1031 exchange, why house flippers are not allowed to do a 1031 exchange. You cannot exchange into something that you already know that you are going to turn around and sell, because the IRS takes that out of the real estate category and puts that into a term they use, which is called inventory, meaning something that you've got metaphorically sitting on the shelf to replace with something else, because you didn't really intend to hold it indefinitely. You bought it with the intent to turn around and flip it to replace it. And that's how you get yourself in trouble in an exchange. So the short answer is no. There's nothing out there that is designed to be a short-term 1031 parking mechanism, because the whole idea of 1031 exchanges was to allow people who wanted to stay in the business of being a landlord to not have to pay taxes as a result of changing real estate, even though they're staying in the business of being a landlord. But it's not intended to protect people who are treating real estate as inventory. And so you need to make sure when you buy something that you can defend your intent at the time to hold that property. Now, having said everything I just said, if you buy a bona fide 1031 property and you intended to own it for 10 years, and 6 months later someone comes along and makes you an offer you can't refuse that you didn't know was going to come, you are allowed to sell that property. There's no rule that you have to hold on to a property for an extended amount of time. There's just a rule that you had the intent at the time that you bought it to hold it for an indefinite period. And I hope that distinction makes sense. So it's not what happened, it's what was your intent on what would happen at the time that you acquired the property that the IRS cares about. And as long as you can make an argument in an audit that you had the intent to hold the property indefinitely, even though you sold it 6 months later, you may survive an audit and be able to, to defer the taxes. You're definitely raising a red flag when you do an exchange and
It's a
then
little
on your next.
suspicious. It's a little suspicious, like, but I suppose if you have a good enough reason, and definitely talk to a good 1031 exchange advisor, to see. Diane, how safe is putting your 1031 exchange into a DST?
Well, there is nothing about the DST structure itself that impacts the real estate risk of the underlying property. So there's owning a property in the form of a DST. It doesn't make the risks, the economic risks of occupancy and supply and demand and macroeconomic and everything else that affects the value is not impacted by the DST. The safety, some people translate that to liquidity. And so, I think the biggest distinction from an ownership perspective, when you in terms of safety, is, can you easily get out of that property? And the answer is no. These are illiquid. When you invest in DST, you are along for the ride, and until the DST sponsor sells that property 5, 6, 7, 8 years later, you just have to wait. And if you define safety as being the ability to get out, on your own without being subject to the decision making of the DST sponsor, then yeah, that's a different story. But DST real estate is actually, in my opinion, at the boring end of the real estate spectrum. It's institutional real estate. The stated objective of most of these programs is principal preservation and income, more than appreciation. And so in that sense, I'd say DSTs are relatively safe, but you can lose your money in a DST investment just like you could lose money in any real estate investment through an LLC limited partnership or something you went and bought on your own.
Yeah, I think that's a really good point. DSTs aren't meant to be super crazy risky investments. These institutions have a lot of people's money on the line, so that helps. And Rick, you have an excellent selection of DSTs that you work with. So, if any of you want to invest into a DST, you don't necessarily even have to do a 1031 exchange, as I understand. You can just, if you wanted to just own real estate in a DST passively, you certainly could. The only thing is as Rick said, and we always get this question, is like, can I sell it? Like, what if I need the money later? It should be money that you don't need for 6, 7 years, and that's really the difference, is that, and you're going to be very passive in it, and essentially, less return, less risk in that sense, but certainly easier, right, than doing all the landlord stuff every day. So I know we received a couple of questions in the chat. David's asking if you could see the questions. So what I can do tomorrow, I can send you a list of all the questions that were asked, and the recording, of course, so you can review all of the responses that Rick had. If we didn't get to your question because it was very specific, Rick is going to be reaching out to you so that he can maybe get some more detail and give you a better response. But thank you so much, Rick, for sticking along, and all of you as well. Please take the exit survey. I'm going to send you the recording. I'm going to send you the slides and Rick's info. No worries about that. And yeah, thanks for sticking around, Rick. You're always so generous with your time, and we really appreciate your insight.
Well, thank you, and sorry for the less than ideal sound today. Hopefully you can
Yeah.
hear me. But I look forward to getting all your questions and answering them, and we'll see you on the next webinar.
Okay. All right, guys. Take care. Have a wonderful day. Bye.
Thanks. Bye.